Welcome to the OCO Roundtable podcast. My name is Meshack Kwaka, an associate at Oraro & Company Advocates, practicing under the Dispute Resolution Practice Group. Joining me is Brian Waguma, who is equally an associate under the Disputes Resolution Practice Group. Today, we will be discussing emerging decisions from the Employment and Labor Relations Court that have changed the landscape of employment law and labor relations. Let's just dive in straight because this is bound to be a very important and intriguing discussion. We are aware that the courts have made various decisions on various concerning topics in employment, and we would like to explore those topics in order to better ourselves. So, Brian, the courts have made or discussed decisions regarding the threshold of disability. Kindly discuss with us what is that threshold, how important is that threshold, and in what cases have the courts decided this threshold?
Yeah, indeed, the jurisprudence that are emerging in the area of employment law and labor relations has also affected the whole concept of disability inclusion. Courts have been, in numerous occasions, forced to deal with issues related to disability. One such case sought to set out the threshold of disability, and this must be understood not to be a creation of the courts, because courts were simply giving meaning to what the Constitution has already provided for under Article 260. And Article 260 of the Constitution defines what disability is. And disability in that article, in summary, is defined as any physical, mental, or sensory impairment that adversely impacts on the person's economic, social, and generally their environment, such that it hinders their normal activities, and that is the standard courts have used in deciding the question of disability.
Quite interesting, because if I've heard you right, you have stated that the courts have been confronted with the question of defining who a person with disability is. In that regard, do we have any cases that come to mind?
Yeah, it's an interesting issue, because for it to get to a point where the court has to answer the question of whether there is a threshold of disability, it means that this is something that has appeared before court in several occasions. And the most notable one is the case of Kirimana versus the National Council for Persons with Disability, which concerned the denial by the council to recommend the petitioner for tax exemption by the Kenya Revenue Authority. And this being a case of tax exemption, it is worth to note that it arose from an employment relationship, because remuneration of PWDs is done just like other employees without disabilities, meaning that if a person with disability has not been exempt formally from tax, then they will be required to pay taxes just like any other employee. And it is the reason why most employees with disability would, upon getting employment, apply with the council to be exempt from taxes.
I'm liking the build-up of this discussion, and those were really insightful views on the disability threshold. But I would ask, why is defining the threshold of a person living with disability very important?
Defining disability or its threshold is of importance because there are rights attached to disability. For example, when you are certified as a person with disabilities, there are certain rights that are specific to you as a person with disability, which is actually considered a privilege, because this right is it will only accrue to you if it is proven that you are a person with a disability, meaning that will be the point where you will have to prove that you have a disability. And some of those rights include exemption from income tax. You are also entitled to provision of assistance by the National Council for Persons with Disabilities. You are also entitled to, in employment, extension of retirement age when working in a public body. So while others' retirement age is set at 60, those who are without disability, for persons with disability, that age is set at 65. That is the implication the definition of disability has on employment for persons with disabilities. Maybe to just clarify on the origin of disability threshold as an issue in employment for persons with disabilities, this came from the tax exemption process where an applicant is vetted to ascertain whether their disability affects their daily lives. And like in the case of Kirimana, the petitioner was found by the vetting panel to be having a disability which was not affecting his daily life, and on that basis, he was denied exemption, and he sued on the basis of discrimination, and that was the moment when the court was invited to determine the question of disability threshold. Is it a relevant issue? Are there categories of disability, or a person once certified as having disability is entitled by virtue of the definition given under the Constitution to all rights that exist for persons with disabilities?
That was very insightful. And just for our audience, what laws or legislation in Kenya govern persons with disability?
The specific laws that govern the rights of persons with disabilities is the Person with Disability Act, enacted in 2003, and this has been amended in 2012 to align it to the Constitution. And we also know that the Constitution is the supreme law that provides the ultimate basis on employment of persons with disabilities, and Article 54, plus also other international instruments that are ratified by Kenya, and by which effect they become part of the Kenyan law pursuant to Article 25 of the Constitution.
Thank you, Brian, for that brilliant discussion on the threshold of persons with disability. We are also ready to discuss regarding employment contracts, and we have seen a lot of decisions emerge from the Employment and Labor Relations Court regarding voiding of an employment contract. What are your thoughts on voiding an employment contract, and do you have any cases that come to mind immediately with regards to that topic?
In cases of employment contracts that have been voided by the court, my view is that the relationship will still be there between the employer and the employee, and the nature of that relationship will be construed based on the Employment Act, which seeks to protect the interests of the employee, as the employee is the part with the low bargaining power. And in this case, I would associate my views with the ELRC decision in Guerra versus Uraisa Limited, where the court voided the employment contract because the employer was found to have forced the employee to enter that contract in order to be entitled to the benefits that comes with employment contracts. And this happened after the employee had quit his previous job, and this employee was a foreigner, and the court found that the employer took advantage of the situation of the employee to coerce him into entering this contract that was found to be void. In the circumstances, the nature of the employment relationship will be that of a month-to-month contract that can be terminated by 28 days notice by either party.
Brian, I'm curious to know what compensation was awarded under this case.
The ELRC court awarded full compensation of 12 months, bearing in mind that the employer had made the employee to quit his job in a foreign country. This was a foreign national, came to Kenya, was, if I would say, trapped to sign that contract because he had no other choice. And because the totality of the circumstances were in favor of granting maximum compensation to the employee, the court went ahead to give 12-month compensation as sought, although that still remains, and this was acknowledged by the court, a matter of discretion. And after the court looking at the circumstances, it found it fit to award maximum compensation to the employee.
Thank you, Brian. Just listening to you reminded me of an issue that normally comes up constantly. That is, what is the difference between a contract for service and a contract of service? And tied with that would be the question of who an independent contractor is and who an employee is. Now, I'll take a brief moment to just explain to our audience what a contract of service is. Section 2 of the Employment Act 2007 defines a contract of service as an agreement, whether oral, written, or whether express or implied, to employ or to serve as an employee for a period of time, which includes a contract of apprenticeship and indenture labour. A contract for service, on the other hand, is a contract which a person, contractor, or service provider makes a commitment to another person, the client, to carry out material or intellectual work at a fee or at a price. It is interesting because in the case that I'm about to highlight, dealt with the question of a contract of service and a contract for service, and also went deeper into the question of whether a person is an employee or an independent contractor. In the case of Benjamin Joseph Omusamia versus Upper Hill Springs Restaurant, the claimant filed suit claiming to have been employed by the respondent as a cook, but his termination was in 2016. The respondent denied that the claimant was an employee and insisted that the claimant was always an independent contractor. In this case, the judge emphasized the control test in determining whether the claimant was an independent contractor or was an employee. While the court appreciated that the control test was to be used, it also stated that you must look at the total relationship of the parties. To highlight the control test, we must first look at its elements. That is, one assesses the presence or absence of a control manager or supervisor, and also looks at the extent to which that supervisor has control over the worker. The second element is the fourfold test, which has sub-elements and looks at the characteristics of control, ownership of the tools, chance of profit, risk of loss, and the integration test. Basically, the integration test looks at whether the role played by the worker is an integral part of the business, but which has not been integrated. On the flip side, to determine whether one is an employee employed under a contract of service, the court quotes and expounds on the contract of service. It looks at whether the servant or the worker agrees to provide skill and services in exchange of wages and a salary. It also looks at whether the worker agrees to subject themselves to a level of control. This can be in terms of supervisory control, agrees to a place in which he will work, a time in which he will report to work, and the method in which he will do the work. And lastly, the court also looks at whether the agreement complies with the statutory requirements, meaning then that contract will be subject to statutory requirements, the Employment Act being the Employment Act 2007. Perhaps a clearer case that analyzed the difference between independent contractor and an employee is the case of Kenya Hotel and Allied Workers versus Alfajiri Villas. In this case, it stated that to identify an independent contractor, you will have to look at the following elements. That the worker will be a registered taxpayer, the worker will have his own hours, run his own business, will be free to carry out work for more than one employee, will receive an invoice from the employer each month, will not be subjected to deduction of pay, and is not granted sick leave or annual leave. Therefore, this discussion, if you keenly follow it, you will see that a contract of service defines an employee under the Act, and a contract for service applies to an independent contractor. Another issue that normally comes up in the Employment and Labor Relations Court is whether a claimant can seek refunds of statutory deductions such as NHIF and NSSF. I came across an interesting case cited as Stephen Bukebi Semiu versus Nzoia Sugar Company Limited. In this case, the claimant, a retired employee, filed a claim against the respondent, who was his former employer. The claimant sought a refund of unremitted deductions with interest and salary arrears. It was the claimant's case that he was entitled to gratuity that was not paid, a 6% salary increment and a 6% pension increment, which was not paid. So the issues in the case were very clear. Whether a court sitting and deciding on this case was able to grant a refund of NHIF, NSSF, and RBA. These were deductions that were made on the employee's payslip but were never remitted. So the court held that the refund of unremitted funds to statutory bodies made on their payslips ought to be a claim lodged with the statutory body that has the mandate and powers to levy and appropriate those penalties. If I would ask you, Brian, would you agree with these emerging decisions from the court, given that there has been a consistency in the courts stating that no refunds will lie with the claimant, but with the statutory bodies?
Absolutely. I will agree with the decision, because when an employee is remunerated, there are deductions that come with such remunerations. And those deductions are to be collected by the entities mandated to undertake those collections. And in the event there is termination, then the employee will only be entitled to the amount that accrues to him or her after the said deductions are done. Even upon termination, the amount an employee is entitled to is still subject to deduction. So I don't think it will be the right thing for an employee to claim unremitted deduction. That should be a matter to be lodged by the entities that are required by law to make those collections.
I would agree with you. I wouldn't add anything on that. But moving on, we had something on probationary contracts. Would you have any authorities recently that have been decided in court and that would enlighten our listeners on probationary contracts?
Yeah, perhaps what is of, or what might be of interest to our listeners regarding probationary contract is about the extension of probationary contract. There are tendencies of employers not being keen on this issue, which eventually turns out to be problematic to them. First, the law defines a probationary contract as a contract which is not of a period of more than 12 months. When you look at Section 42(1) of the Employment Act, it requires that a probationary contract should not be of more than 6 months, provided that the same can be extended for a further period of not more than 6 months. Meaning that if you are giving an employee a contract of probation for the maximum period stipulated under the Act, that being 6 months, it cannot be, and if you are to extend the same period, then the maximum period an employee can serve under a probationary contract will be 12 months. The question is, assuming you have given an employee a probationary contract, amounting to 6 months, and then you have not renewed this contract, the employee continues working for a period of, say, 4 months, and then later you come with a contract saying that you are now extending this probation period to a further 6 months. The court have said, and this is a decision that was recently rendered in Daniel Mutuku Nchuguda versus Kenya Institute of Mass Communication, where the court said that the extension of the probationary period must be continuous with the initial period, meaning that upon lapse of the initial contract of probation, then that extension must take effect immediately. So if a contract expires on 31st of July, then the renewal must kick in from August 1st, meaning that if the employee has served for a period after the lapse of the probationary period without the extension, then that employee, if it leads to a case of termination, he will be entitled to the process under Section 41 because he will be treated as an employee.
Quite interesting. Just to clarify, is it that upon the lapse of your probationary contract period, you automatically become an employee if the employer does not communicate any word as to whether you have been employed or not?
The question as to whether you automatically becomes an employee will be determined on a case-to-case basis. This will be dependent on the facts. For example, if upon lapse of your probation period, you continue serving the employer and you continue receiving remuneration, and the employer treats you, the conduct of the employer is sufficient to deem you as an employee, then those facts will work in your favor and the court will deem you to be an employee, not under the probation period, because in the absence of a written contract, then that relationship will have to be construed in favor of the employee. In the case I have cited, Daniel Mutuku versus Kenya Institute of Mass Communication, the probation period of employment had lapsed. The claimant had been given a 6-month probation period and continued working after the lapse of the probation period for 5 months, after which the employer sought now to renew the probation period. And this was found to be illegal by the court because the court said that it is not upon the employer to choose when to renew the probation period. It has to be strict. The intention of the drafters of the Employment Act was that this probation period was not to go beyond the period of 12 months. If the period worked by the employee after the 6-month lapse of the probation period, these 5 months he's been working, if it was taken into account, then it means the person has already worked for almost 12 months and you cannot purport to later come and extend the period that lapsed 5 months prior to now continue holding this person under probation period. So it is on a case-by-case basis, but by conduct, if you continue working for the employer and you continue receiving the remuneration upon lapse of that probation period, it means that you are deemed as an employee, absenting any written contract. So the provisions of the Employment Act that applies to employees will apply to you.
Thank you, Brian. On that note, we come to the end of our discussion, and I would like to thank Brian Waguma for the fruitful contributions. We also value your feedback, and be sure to like and subscribe and also follow us on our social media platforms. Goodbye and take care.